Welcome. Today's session is titled Work Regulations. We will proceed strictly by the material on each slide. By the end of this training, participants will have knowledge of labor legislation relevant to workplace practice. Upon completion, you will be familiar with the key legal frameworks: Occupational Health and Safety Law Number 6331, Labor Law Number 4857, and Social Insurance and General Health Insurance Law Number 5510. This section introduces Law Number 6331 on occupational health and safety, the baseline for OHS duties, rights, and procedures. Law Number 6331 applies to all public and private jobs and workplaces, their employers and representatives, and all employees, including apprentices and trainees, regardless of the field of activity. Reiterating the scope, the law covers every sector, addressing workplaces, employer representatives, and employees without limitation by activity type. The law does not apply to certain activities and persons, for example, specific operations of the Turkish Armed Forces, law enforcement, and the National Intelligence Organization, disaster and emergency interventions, domestic services, individuals working on their own without employees, and activities linked to correctional programs. Key definitions: the Ministry of Labor and Social Security, the employee regardless of status, the employee representative authorized for OHS participation and oversight, and support staff assigned, besides their main duties, to prevention, protection, evacuation, firefighting, and first aid with proper equipment and training. Training institution: bodies authorized to train OHS specialists, occupational physicians, and other health personnel, includes universities and eligible company institutions. Young worker: an employee aged 15 to under 18. Occupational safety specialist: a ministry-authorized professional holding the required certificate. Work accident: an incident at or due to work causing death or physical/mental disability. Employer: any natural or legal person or non-legal entity that employs workers. Workplace: the organized setting for producing goods/services, including associated areas such as restrooms, dining, nursing, training, and care rooms. Workplace physician: a ministry-authorized physician. Workplace health and safety unit: an on-site unit equipped and staffed to deliver OHS services. Council: the National Occupational Health and Safety Council. Committee: the Workplace OHS Committee. Occupational disease: illness arising from occupational exposure. Joint Health and Safety Unit: an authorized external OHS provider. Prevention: planned measures to eliminate or reduce OHS risks. Risk: the likelihood of loss, injury, or harm from a hazard. Risk assessment means identifying hazards, analyzing their causes, evaluating risks, and setting control measures. Hazard refers to the potential for harm or damage within or outside the workplace. This section introduces the responsibilities, authorities, and obligations of both employers and employees under Law Number 6331. Employers are responsible for workplace health and safety. They must take necessary measures, prevent risks, provide training and information, supply equipment, adapt to new conditions, and continuously improve the safety system. The employer's duty remains even when outside experts are hired. Costs of OHS cannot be charged to employees. Employers must monitor compliance, conduct risk assessments, match tasks with employee capability, and prevent unauthorized entry into dangerous areas. Key principles include avoiding risks where possible, and carefully analyzing any risks that cannot be fully avoided. Employers must address risks at their source. Workplaces, equipment, and methods should be designed to suit workers, preventing the negative effects of monotony and workload. Employers should adapt to technical progress, replace hazardous processes with safer ones, develop a broad prevention policy, prioritize collective protection over personal equipment, and provide clear instructions to workers. Employers must provide OHS services by appointing a certified safety specialist, an occupational physician, and health personnel in hazardous workplaces with 10 or more employees. If not available in-house, these services can be obtained from joint health and safety units. Workplaces with fewer than 50 employees, classified as low risk, may handle OHS services internally, except for medical exams, if the employer or representative completes the required ministry training. Employers must supply adequate resources, ensure cooperation among OHS staff, implement written safety measures, and inform both in-house and external workers of any known health and safety risks. If a full-time workplace doctor is present, other health staff may not be required. The ministry may provide financial support for workplaces with fewer than 10 employees in hazardous categories. Expenses are covered by the Social Security institution using funds from work accident and occupational disease premiums. Employers who fail to report employee insurance lose eligibility for support for 3 years. The ministry is authorized to resolve uncertainties and guide the proper implementation of support mechanisms. The ministry, with the approval of the Ministry of Finance, regulates how support for OHS services will be applied. This includes how service fees are determined, which workplaces qualify, and the standards for organizations providing OHS services. Collaboration may also be established with other ministries and professional bodies to ensure effectiveness and continuity. Occupational physicians and safety experts have rights and authority that cannot be restricted while performing their duties. They must act with ethical principles and professional independence. Their role includes identifying deficiencies and risks, advising the employer, and reporting their recommendations in writing. The employer, in turn, is responsible for correcting deficiencies and implementing measures. If deficiencies present an urgent and life-threatening danger, such as fire, explosion, collapse, or chemical leak, the occupational physician or safety expert must immediately notify the ministry's authority. If a union representative or employee representative is present, they must also be informed. If an occupational physician or safety expert fails to report such dangers, their license can be suspended for 3 months or 6 months for repeated offenses. Employers cannot dismiss or penalize them for fulfilling this duty. If they do, compensation of at least 1 year's salary is required. However, if it is proven in court that the report was made in bad faith, the expert's license is suspended for 6 months. OHS service providers are liable for negligence that causes harm. If such negligence results in death or disability, the professional's license will be suspended. Safety experts must hold certifications: Class A for highly hazardous workplaces, Class B for hazardous, and Class C for low risk. The ministry may also issue sector-specific regulations, for example in mining or construction, on which professional titles are prioritized. Where the law requires full-time occupational physicians and safety experts, the employer must establish a workplace OHS unit. Public sector workers with the necessary qualifications may also serve as workplace physicians or safety experts within their own institution or, with consent, in other institutions. Those working as occupational physicians or safety experts in public institutions are entitled to additional pay. The payment is calculated per hour using an index set by civil servant rules. No deductions, other than stamp duty, are applied. Assignments beyond 80 hours per month are not counted, ensuring fairness and compliance with working time rules. Other legal restrictions do not prevent workplace doctors and health staff from being assigned to workplace OHS units or joint units. Their duties are limited to serving employees in the designated workplaces, ensuring focus on their specific responsibilities. Workplace hazard classes are determined by the ministry based on insurance premium rates under Law No. 5510. The primary work activity at a workplace is the deciding factor, and the process is carried out with input from the OHS General Directorate and relevant committees. Employers are responsible for ensuring a risk assessment is carried out. The assessment must consider employee conditions, equipment and chemical selection, workplace organization and layout, and the special needs of groups such as young, elderly, pregnant, or disabled workers. Following the assessment, employers must determine protective measures and equipment. These measures must enhance worker safety across all levels of management. Employers must also ensure continuous controls, measurements, inspections, and research to monitor the work environment and employee exposure to risks. Employers must evaluate potential emergencies such as fire or hazardous material release and plan preventive and protective measures. They must prepare emergency response plans, assign and train enough staff for evacuation, firefighting, and first aid, and provide proper drills and equipment. Employers are also responsible for ensuring communication with external emergency services and medical teams. In situations of serious, imminent, and unavoidable danger, the employer must have plans in place for immediate evacuation. Employees must be able to leave the workplace quickly and move to a safe location. Clear instructions must be given in advance. If the danger continues, no worker, other than those specifically assigned and equipped, should be required to remain. Workers are also allowed to act within their knowledge and available tools to prevent harm when supervisors cannot be informed in time. They are not held responsible for such actions unless they act recklessly. Employees who face serious and imminent danger have the right to request an assessment by the Workplace Safety Committee or, if none exists, directly from the employer. The committee must meet immediately, and the employer must decide without delay, recording the situation in writing. If the request is accepted, the employee may stop working until corrective measures are taken. During this period, all wages and legal rights remain fully protected. When a danger is so immediate that it cannot be prevented, employees can leave the workplace or hazardous area without following the usual procedures. Their rights cannot be restricted for taking this action. Furthermore, if necessary measures are not implemented despite a request, employees may terminate their employment contract according to labor law. For public workers under collective agreements, the time they refrain from work under this article is still counted as if they worked. Employers must keep detailed records of all workplace accidents and occupational diseases. They are required to investigate every incident and prepare formal reports. Even incidents that do not cause injury or death but result in damage to equipment or have the potential to harm employees or facilities must be documented and analyzed. Employers must notify the Social Security institution promptly. Work accidents must be reported within 3 working days, while occupational diseases reported by a physician must also be communicated within 3 working days of becoming known to the employer. Occupational physicians or healthcare providers must refer suspected occupational disease cases to institutions authorized by the Social Security institution. Healthcare providers are obligated to report both workplace accidents and confirmed occupational diseases to the institution within 10 days. The ministry, with input from the Ministry of Health, sets out the procedures for these notifications. Employers must ensure health surveillance for all employees, tailored to the risks they may face at work. Mandatory medical examinations must take place at hiring, when changing jobs, upon return after an accident, illness, or occupational disease, and at intervals determined by the ministry based on job type, hazard level, and workplace classification. No employee may be placed in hazardous or highly hazardous work without a valid health report confirming fitness for duty. These reports must come from workplace physicians or, in small, low-risk workplaces, from public health providers or family physicians. Appeals against reports go to arbitration hospitals designated by the Ministry of Health, and their decisions are final. All expenses related to health surveillance are paid entirely by the employer, never by the employee. Confidentiality is guaranteed. Personal health data must be kept private, protecting the dignity and reputation of each worker. Employers are obliged to inform employees and their representatives about workplace health and safety risks, the protective measures in place, and their legal rights and responsibilities. They must also identify and communicate the names of those assigned to first aid, emergency response, firefighting, disaster response, and evacuation duties. Information must be provided without delay to employees exposed to imminent danger, detailing both current risks and the measures taken. Employers of outside workers who enter the workplace must also be informed. Additionally, employee representatives and support staff must have full access to records and reports of risk assessments, technical controls, and preventive measures to monitor compliance. Employers must provide occupational health and safety training to all employees. This training must be given before starting work, when changing jobs or equipment, or when new technologies are introduced. It must be updated regularly to reflect new risks and repeated at necessary intervals. Employee representatives are to receive additional specialized training so they can carry out their roles effectively. In hazardous and highly hazardous workplaces, vocational training is mandatory. No employee can be employed in such jobs unless they can prove that they have received the relevant vocational training. Additionally, workers who have suffered an accident or contracted an occupational disease must be provided with extra training. This training focuses on the causes of the accident, the preventive measures, and safe working methods. It is also stated that employees who have been absent from work for more than 6 months must undergo refresher training before returning. Finally, in hazardous workplaces, workers coming from other jobs cannot be employed without certification confirming that they have received sufficient occupational safety training. Employers who establish temporary work relationships must ensure that employees receive all necessary occupational safety training. Importantly, the cost of such training cannot be charged to the employees. Training time must be considered as part of working hours. If the training exceeds regular weekly hours, then that time is counted as overtime or extended working hours. This rule protects employees and ensures that safety training is never treated as a personal burden. Employers are required to provide opportunities for employees, or, in the absence of employee representatives, trade union representatives, to give opinions and take part in discussions. This is a key element of building a participatory safety culture within the workplace. Employee representatives must be consulted on health and safety issues. They must be given the right to make suggestions and actively participate in discussions. Moreover, they should be consulted before the introduction of new technologies, the selection of work equipment, and changes in the working environment that may affect health and safety. This ensures that workers' voices are heard in decisions that directly impact their safety. The employer must seek opinions of employee representatives on specific matters. These include the appointment of occupational physicians, safety specialists, and other staff responsible for first aid, firefighting, and evacuation. Representatives must also be involved in risk assessments and in decisions about protective measures and equipment. This reinforces their role as a bridge between management and the workforce in safety matters. Further obligations include consulting representatives on prevention of risks, the delivery of protective services, the planning of employee training, and informing workers about hazards. Importantly, employees retain the right to report to competent authorities if workplace measures are insufficient, and they cannot be restricted or penalized for doing so. This provision strengthens transparency and accountability. Employees also have clear responsibilities under occupational safety law. They must avoid endangering their own health or the safety of others. In line with the training and employer's instructions, employees are required to use all machinery, tools, and hazardous substances in compliance with safety rules. They must also use protective equipment properly and refrain from removing or altering it without permission. Additional responsibilities include using and maintaining personal protective equipment correctly, immediately notifying the employer of any serious hazards or deficiencies, and cooperating with management in correcting unsafe conditions. Employees are also expected to collaborate with safety representatives in ensuring compliance with safety regulations. In short, workplace safety is a shared responsibility. Workplaces with up to 50 workers must have one representative, while workplaces with over 2,000 workers must have at least 6. The appointment should ensure a fair distribution across different workplace areas, either through election or employer designation if an election is not possible. When multiple representatives exist, a chief representative is elected among them. Representatives have the right to make recommendations to the employer and request measures to eliminate hazards. They cannot be penalized for carrying out their duties, and employers must provide them with necessary facilities. Additionally, if a trade union exists in the workplace, its representatives also serve as employee representatives. At the national level, Article 21 establishes a council to provide advice on health and safety strategies and policies. This council operates under the ministry and includes the general directors of key labor and inspection bodies, as well as representatives from the Social Security Institution. The purpose is to coordinate safety policy across the country with input from multiple ministries. Membership extends to the Council of Higher Education, the State Personnel Presidency, employer and employee unions, chambers of commerce, engineers, architects, doctors, and farmers. If necessary, additional experts or institutions can be invited. This broad representation ensures that occupational safety policies are shaped by a wide range of social, professional, and industrial stakeholders. Members are elected for 2 years, and if they fail to attend 2 consecutive meetings, their membership is terminated. The Secretariat is managed by the General Directorate of Occupational Health and Safety. The Council makes decisions by simple majority, and in the case of a tie, the chairperson's vote is decisive. Abstentions are not allowed. Regular meetings take place twice a year, while extraordinary sessions can be held if proposed by the chairperson or 1/3 of the members. All procedures and principles of the Council are determined by the Ministry under Law No. 6331. In workplaces employing 50 or more workers and where continuous work lasts more than 6 months, the employer is obliged to establish an Occupational Health and Safety Committee. This committee is responsible for carrying out occupational health and safety activities, and the employer must implement its decisions in compliance with legislation. This ensures a structured approach to workplace safety under Law Number 6331. When there is a principal-employer and subcontractor relationship lasting more than 6 months, the law requires strong coordination. If both parties have committees, the principal employer must ensure cooperation. If only the principal employer has a committee, the subcontractor must appoint a representative. If only the subcontractor has a committee, the principal employer must assign a representative to cooperate. And if their combined workforce exceeds 50 employees, they must establish a joint committee coordinated by the principal employer. These measures secure consistent safety practices across multiple employers under Law Number 6331. The monitoring and enforcement of occupational health and safety laws are carried out by Ministry labor inspectors. They are authorized to conduct inspections, research, measurements, and sampling in workplaces. Inspectors must respect trade secrets and minimize disruptions during inspections. Special procedures apply to military workplaces and those critical for national security, which are jointly regulated with the Ministry of National Defense. These duties emphasize the Ministry's authority to ensure compliance with occupational safety regulations under Law Number 6331. If a serious and imminent danger is identified in workplace buildings, methods, or equipment, work can be suspended partially or entirely until the risk is eliminated. For highly hazardous industries, such as mining, metal, construction, or work involving hazardous chemicals, suspension is mandatory if a risk assessment has not been conducted. A committee of 3 labor inspectors reviews such cases within 2 days, but urgent situations allow immediate suspension by a single inspector. The decision to suspend work must be delivered to the local administrative authority and enforced within 24 hours by law enforcement. In urgent cases, enforcement is immediate. Employers can appeal to the labor court within 6 working days, but appeals do not suspend enforcement. The labor court must review the case promptly and issue a final ruling within 6 days. These strict timelines ensure that worker safety is not delayed by procedural appeals. If the employer resolves the dangerous conditions and informs the Ministry in writing, an inspection is conducted within 7 days to confirm compliance. During suspension, the employer is obliged to continue paying employee wages or provide alternative jobs without wage reduction. In highly hazardous industries, unsafe working conditions resulting from excessive production pressure are also grounds for suspension. Moreover, any employer or representative authorizing work during suspension faces imprisonment of 3 to 5 years, highlighting the seriousness of compliance. Employees are strictly prohibited from coming to work under the influence of alcohol or drugs, or from consuming them at the workplace. However, the employer has the authority to define under which circumstances alcoholic beverages may be consumed in certain workplace areas, such as during formal events or designated areas. This ensures control over substance use while maintaining safety. The prohibition on alcohol consumption does not apply to specific cases. Employees inspecting alcoholic beverage production, employees required to taste or consume alcohol as part of their duties in sales or service, and those whose job requires them to drink with customers. These exceptions are narrowly defined to support professional requirements without undermining workplace safety. Before starting operations, employers in workplaces where major industrial accidents may occur must prepare either a major accident prevention policy or a detailed safety report, depending on workplace size. Those preparing a safety report may only begin operations after its adequacy has been reviewed and approved by the Ministry. This process ensures preparedness against large-scale accidents and compliance with Law Number 6331. This slide introduces the Labor Law Number 4857, which complements occupational health and safety regulations by covering broader employment rights and responsibilities. It is one of the cornerstone laws regulating employer-employee relationships in Turkey. The purpose of Labor Law number 4857 is to regulate the rights and responsibilities of employers and employees under an employment contract, specifically concerning working conditions and the work environment. This law establishes the legal framework for fair, safe, and regulated labor practices in the workplace. This law applies to all workplaces and their employers, representatives, and employees regardless of the type of activity carried out. However, there are certain exceptions. For example, maritime and air transport operations are excluded. Similarly, agricultural and forestry workplaces with 50 or fewer employees are outside the scope. Work related to agriculture that is part of the family economy, as well as handicrafts produced at home by family members up to the third degree without outsiders, are also exempt. Domestic services, activities involving apprentices, athletes, and rehabilitated individuals, as well as very small artisan workplaces as defined in the Craftsman and Artisans Law, are likewise excluded. In employment relationships, discrimination on the basis of language, race, color, gender, disability, political opinion, religion, sect, or similar grounds is strictly prohibited. Employers are not allowed to treat part-time employees less favorably than full-time employees, or to treat fixed-term workers differently from indefinite-term workers, unless justified by valid reasons. Likewise, employees cannot be treated differently in the establishment, implementation, or termination of contracts based on gender or pregnancy, unless biological reasons or the nature of the work make such treatment necessary. The principle of equal treatment also extends to wages. It is not permissible to agree on lower wages for the same or equivalent work simply because of an employee's gender. Special protective provisions that exist for women cannot be used as a justification for paying lower wages. In short, equal pay for equal work is a fundamental rule guaranteed by the labor law. A temporary employment relationship may be formed in specific ways. It can be established through a private employment agency or by assigning a worker to another workplace within the same holding or group of companies. This arrangement is particularly valid when an employee is absent due to military service or when the contract is suspended for other reasons. Temporary employment is also permitted in seasonal agricultural work and in domestic services. Beyond seasonal and domestic work, temporary employment may also be established in certain special cases. These include work that is not part of the company's daily operations and occurs intermittently, or when there is an urgent need for occupational health and safety measures. Temporary employment may also be allowed when compelling reasons arise that significantly affect production. Additionally, if the company experiences an unforeseen increase in production capacity that requires extra workers, temporary employment may be established. However, apart from seasonal work, such arrangements are limited to situations of periodic work increases. An employment contract is an agreement where one party, the employee, undertakes to perform work in a dependent relationship, and the other party, the employer, agrees to pay wages. Unless otherwise required by law, an employment contract does not need to follow a specific format. However, contracts lasting 1 year or more must be in written form. If a written employment contract is not concluded, the employer must provide the employee with a written document within 2 months at the latest. This document must specify working conditions, daily or weekly hours, wages and supplements, payment periods, the duration of the contract if it is fixed term, and the rules that apply in case of termination. This ensures clarity and protection for both parties. Employment contracts can be definite or indefinite in duration. They may also be full-time, part-time, probationary, or of other forms depending on the work. By law, jobs lasting 30 working days or less are classified as temporary work, while those exceeding this duration are considered permanent work. This distinction helps determine employee rights and obligations. When an employee's normal weekly hours are significantly less than those of a comparable full-time employee, their contract is considered part-time. Importantly, part-time workers may not be treated differently simply because of their status, unless there is a valid reason. Wages and other divisible benefits must be paid proportionally to their working hours, ensuring fairness between part-time and full-time employees. On-call work is a part-time employment relationship where the employee agrees, in a written contract, to perform duties only when needed. The worker does not have regular hours, but instead works when called upon by the employer. This type of arrangement provides flexibility but still requires written agreement and legal protections. If the contract does not specify how many hours the employee will work in a week, month, or year, the law presumes 20 hours per week. Regardless of whether the employee is actually called to work, they remain entitled to their wages. This ensures income security in on-call arrangements. When a probationary period is included in an employment contract, it cannot exceed 2 months. However, collective agreements may extend it up to 4 months. During this trial period, either party may terminate the contract without notice or compensation. The employee, however, retains their right to wages and benefits for the days worked. This allows both sides to evaluate compatibility before committing to long-term employment. In cases of termination of indefinite-term employment contracts, the law requires prior notice to the other party. The length of this notice period depends on the employee's length of service: 2 weeks for less than 6 months, 4 weeks for 6 to 18 months, 6 weeks for 18 to 36 months, and 8 weeks for more than 36 months. If a party fails to comply with this requirement, compensation equivalent to the wages of the notice period must be paid. Employers may also choose to terminate immediately, provided they pay the corresponding wages in advance. When an indefinite-term contract is terminated in workplaces employing 30 or more workers, and the employee has at least 6 months of seniority, the employer must rely on valid reasons. These may arise from the employee's performance, qualifications, or from the needs of the business, workplace, or job itself. Termination must always be in writing, and the reason must be stated clearly. Before termination for conduct or performance, the employee has the right to present a defense. Still, the employer maintains the right of immediate termination under Article 25, Paragraph 2. If a termination notice lacks a stated reason or the reason given is found invalid, the employee has 1 month from the date of notification to apply to a mediator requesting reinstatement. Should the mediation process fail, the employee may then file a lawsuit within 2 weeks at the labor court. Importantly, the burden of proof lies with the employer to show termination was based on valid grounds. If the employee claims another reason for dismissal, they are responsible for proving that claim. When a termination is ruled invalid, the employer must reinstate the employee within 1 month. If the employer does not comply, they must pay compensation equivalent to 4 to 8 months' salary. In cases where mediation ends in agreement, the parties must specify the date of reinstatement, the amounts owed for wages and rights, and the compensation to be paid if reinstatement does not occur. If no agreement is reached, a final record is issued, and further legal procedures may follow. An employer may only introduce significant changes to working conditions by notifying the employee in writing. Such changes become valid only if the employee also accepts them in writing within 6 working days. If the employee rejects the changes, the employer may terminate the contract, but must provide a valid reason and follow the required notice procedure. The employee may then challenge this termination through the courts under Articles 17 to 21 of the Labor Code. When an employee leaves a job before the end of their contract or without serving the notice period in order to work for another employer, both the employee and the new employer may be held liable. The new employer's liability arises if they cause this behavior, knowingly hired the employee despite awareness of the violation, or continue to employ the worker even after discovering the breach. In these situations, joint liability applies to both the employee and the new employer. Employees may immediately terminate their contracts, whether fixed or indefinite, if just causes arise. These include health risks directly related to the job, contagious diseases, violations of moral principles such as harassment or insult, or compelling circumstances that halt work for more than a week. This right ensures employees are protected from conditions that endanger their health, dignity, or ability to continue working. Employers also have the right to terminate contracts without notice in certain cases. These include intentional illness or incurable conditions affecting performance, serious breaches of good faith such as dishonesty or crimes, prolonged absenteeism, imprisonment, or compelling reasons leading to work stoppage longer than a week. In such circumstances, the employer may lawfully end the contract immediately, regardless of its duration. Employers are legally required to employ persons with disabilities and, in some cases, former convicts. In private sector workplaces with 50 or more employees, at least 3% must be persons with disabilities. In the public sector, this ratio increases to 4% for people with disabilities and 2% for former convicts. If wages are not paid within 20 days of their due date, excluding compelling reasons, employees have the right to stop working until payment is made. Additionally, overdue wages are subject to the highest applicable interest rate. During this period, the employer may not dismiss the employee, hire replacements, or reassign the work to others. According to labor law, no more than 1/4 of an employee's monthly wage can be garnished or transferred to others. An exception applies to amounts determined by court for the maintenance of dependents, such as alimony obligations. Creditors with claims for alimony debts have priority over other creditors in this context. Employers are required to provide employees with a signed or sealed payroll statement when paying wages. This statement must specify the payment date, the period covered, and all wage components, including overtime, weekend, and holiday pay. It must also list deductions such as taxes, insurance contributions, advances, alimony, and enforcement costs. Transparency in payroll ensures employees clearly understand their earnings and deductions. Any deduction must be explicitly stated in the employment contract or a collective agreement. Even then, the deduction cannot exceed the value of 2 days' wages in a month or 2 days' worth of earnings in the case of piecework or performance-based pay. These deducted amounts are not kept by the employer but must be transferred to an official account designated by the Ministry of Family, Labor, and Social Services. They are later used for employee education and welfare programs. Regardless of the type of work or whether the worker is directly covered under the labor law, a minimum wage must be respected. The responsibility lies with the Ministry of Family, Labor, and Social Services, which sets the official rate through the Minimum Wage Determination Commission. This process takes place at least once every 2 years. Overtime refers to any work that goes beyond the standard 45 hours per week. For each additional hour of overtime, employees are entitled to a higher pay rate. Specifically, the wage is increased by 50% compared to the standard hourly wage. When an employment contract specifies a weekly schedule below 45 hours, any work that exceeds the agreed schedule but does not surpass the 45-hour limit is considered additional time. For these extended hours, the the wage per hour is increased by 25%. Employees are not only entitled to extra pay for overtime, but they can also choose to convert this entitlement into compensatory leave. For every hour of overtime, the employee earns 1 hour and 30 minutes of time off. For extended hours, each hour worked corresponds to 1 hour and 15 minutes of leave. These leaves must be taken within 6 months during regular working hours and without any reduction in salary. Employees who complete at least 1 year of service, including the probation period, earn the right to annual paid leave. The length of this leave depends on seniority. Employees with 1 to 5 years of service are entitled to 14 days. Those with more than 5 years but less than 15 receive 20 days. Employees with 15 or more years of service enjoy at least 26 days. Additionally, younger workers under 18 and older workers over 50 are guaranteed no less than 20 days of leave. As a general rule, normal working hours cannot exceed 45 hours per week. If not otherwise agreed, this is divided equally among the working days. However, flexibility is possible. By mutual agreement, employers and employees may distribute weekly hours differently, as long as no single day exceeds 11 working hours. In some cases, work may be interrupted, such as during force majeure, public holidays, or temporary closures. If working hours are significantly reduced or suspended, employers may request compensatory work. This must be completed within 4 months to cover the lost time. It ensures continuity of productivity without breaching employees' rights, since compensatory work is limited by law and cannot be abused. Employees must be granted rest breaks depending on the length of their workday. For up to 4 hours, a 15-minute break is mandatory. For work longer than 4 hours, but up to 7.5 hours, employees must receive at least 30 minutes. For more than 7.5 hours, the break must be 1 full hour. These breaks are minimum standards, provided without interruption, and are critical for maintaining both productivity and occupational safety. Night work is legally defined as work performed between 8 p.m. and 6 a.m. for a maximum of 11 hours. In workplaces operating day and night shifts, employees rotate between day and night duty, usually on a weekly or bi-weekly basis. Furthermore, after a shift change, employees must be given at least 11 consecutive hours of rest before starting the new shift. Female employees are entitled to a total of 16 weeks of maternity leave, 8 weeks before childbirth and 8 weeks afterward. Beyond that, mothers are granted 1.5 hours daily to breastfeed their children under the age of 1. The employee has full authority to decide how to schedule this time, and it counts as part of normal working hours. We address Social Insurance and General Health Insurance Law Number 5510. Its scope is broad, covering a wide range of employee rights and protections. Within this training, we focus on its connection to occupational health and safety. The law establishes the framework for ensuring that employees have access to medical services, social benefits, and protections against workplace risks, making it a cornerstone of worker welfare in Turkey. This law establishes the framework for providing both Social Security and general health insurance coverage. Its primary goal is to protect individuals by ensuring access to health and social benefits. It identifies who is entitled to benefit, the rights they can receive, the conditions under which these rights are applied, and the financial methods that support the system. In addition, it sets out the rules and principles for how Social Security and health insurance operate. The scope of Law Number 5510 is extremely wide, covering many different aspects of Social Security and health. However, in this training, we will specifically focus on the law from the perspective of occupational health and safety. This means we will only emphasize the parts of the law that are directly connected to workplace safety, employee health, and employer responsibilities under occupational regulations. Law number 5510 introduces some important definitions. The term insured refers to a person who is required to pay insurance premiums or who pays them independently in order to be covered. Social insurance is divided into short-term and long-term schemes. Short-term coverage includes work accident and occupational disease insurance, as well as sickness and maternity insurance. Long-term coverage, on the other hand, includes disability, old age, and survivors' pensions. Finally, general health insurance ensures the protection of people's health and covers medical costs when health risks occur. A work accident, as defined by this law, is an incident that occurs in several possible situations. While the insured person is at the workplace, while working independently on behalf of the employer, or when sent on duty to another location outside the regular workplace. It also covers time spent breastfeeding for insured female workers, as recognized under labor regulations, as well as traveling to and from the workplace if transportation is provided by the employer. If these situations result in the insured person suffering physical or mental harm, whether immediately or over time, it is officially considered a work accident. An occupational disease is any illness or disability that arises due to the nature of the work performed or the conditions under which it is carried out. This includes both temporary and permanent illnesses, as well as physical or mental impairments. The key point is that the disease must be directly linked to the working environment or the type of job. For an illness to be officially recognized as an occupational disease, a careful process is followed. This includes the preparation of a medical report by an authorized healthcare provider, supported by medical documents. Workplace audits are also considered, which examine the working conditions and their connection to the illness. If necessary, other supporting documents are reviewed. Ultimately, the final decision is made by the institution health board, which evaluates all medical and workplace evidence together. When a work accident or occupational disease occurs, several rights are granted to the insured person. These include a temporary disability allowance for the period of incapacity and a permanent disability income if the condition leads to long-term impairment. If the insured person dies, income is provided to their beneficiaries. Additionally, daughters who receive income are eligible for a marriage allowance, and a funeral allowance is also provided in the event of death due to a work-related incident. If a work accident or occupational disease occurs due to the employer's intentional actions or violation of health and safety regulations, the law places financial responsibility on the employer. In such cases, the Social Security institution will recover the payments made to the insured or their beneficiaries from the employer. The calculation is based on the total payments and the initial capital value of income that would have been provided. However, when determining liability, the principle of inevitability is always taken into account. When a work accident or occupational disease is caused by a third party's fault, the law ensures accountability. In such cases, half of the lump sum value of the income linked to the insured person's compensation is recovered from the third party responsible for the damage. If the third party is also employed by an employer, that employer may also share liability. Disability status is determined through medical reports prepared by authorized healthcare providers. For insured persons, disability means losing at least 60% of their working capacity, or losing the ability to perform their professional duties as a result of a work accident or occupational disease. The institution's health committee makes the final decision. Depending on the insured person's employment category, this may be defined as a loss of earning capacity in their profession or a general inability to perform their duties. The Turkish Penal Code number 5237 covers a wide range of legal issues. However, this training will focus only on the parts of the code that are related to occupational health and safety. The purpose of this law is to protect fundamental rights and freedoms, ensure public order, safeguard public health and the environment, and maintain social peace. It also aims to prevent crimes by defining the principles of criminal liability. Within this framework, it categorizes different types of crimes, penalties, and security measures. From the perspective of occupational health and safety, this code emphasizes that protecting employee well-being and preventing workplace risks are not just administrative duties, but also legal obligations that carry criminal responsibility. Every person who commits a crime must face a punishment and appropriate security measures proportional to the severity of their actions. It emphasizes that ignorance of the law cannot be used as an excuse. This principle ensures fairness and accountability under Criminal Code number 5237. The concept of intent is defined as the deliberate and purposeful completion of a crime's legal elements. If a person foresees the potential criminal outcome but still proceeds, this is regarded as possible intent. In such cases, the penalties are severe. Aggravated life sentences may be reduced to life imprisonment or to 20 to 25 years depending on the crime. For lesser crimes, the base sentence is reduced proportionally. Negligence occurs when someone fails to exercise necessary care and diligence, resulting in harmful consequences that were not foreseen. However, if the person could foresee the outcome but disregarded it, this is called conscious negligence, and the penalty is increased by 1/3 to 1/2. In cases involving multiple negligent offenders, responsibility is individual, and punishment is determined separately for each person according to their share of fault. This section highlights the serious consequences of negligent actions that cause death. If someone causes the death of another person through negligence, the punishment ranges from 2 to 6 years in prison. Where multiple deaths occur, or where death is combined with injury to others, the penalty increases significantly to between 2 and 15 years. These provisions stress the weight of responsibility in preventing avoidable harm. This article criminalizes actions that endanger public life, health, or property, or that could cause widespread fear or panic. Such acts include causing fires, triggering building collapses, landslides, avalanches, floods, or using weapons or explosives in dangerous ways. Penalties range from 6 months to 3 years of imprisonment, reflecting the serious risks posed to community safety. These provisions deal with safety in construction and demolition. Anyone who neglects essential precautions to protect life or physical integrity may face 3 months to 1 year of imprisonment or a fine. Similarly, failing to install necessary signs or barriers, or removing them at hazardous sites accessible to the public can result in 2 to 6 months of imprisonment or a fine. These articles emphasize proactive safety management in public and work environments.